Thanks very much. We might just give a second for people to clear out, run away at the prospect of hearing about the GDPR. I wish I could do that. The first thing you'll note from my slides is that we have perfected the miracle of time travel, and it's actually tomorrow. It's the 24th of April, so welcome to the future. So the purpose of this panel, the title being Private Data Public Interest, I suppose, is looking at the privacy and data protection implications of the EHDS from the point of view of the quite significant shift from the sort of very private, sensitive, confidential world of health data to moving into the EHDS space of maximizing access and sharing of health data, both for primary and secondary uses. I might briefly introduce my co-panelists. My colleague Georgetta Botas from the DPC in Ireland, Assistant Commissioner with responsibility for supervision of the health, children's data and voluntary sectors. We're also joined by Anna Maria Mladenic from the Croatian Data Protection Authority, who is Head of Sector for EU International Cooperation and Legal Affairs, and is also Vice Chair of the Committee of Convention 108 of the Council of Europe, which, as some of you may know, is the oldest international organisation dedicated to the protection of human rights, and Convention 108 looks at data protection. We're also joined by Marta Muzadlovska from the University of Ghent, who is a PhD researcher there within the Metamedica framework, which is an interdisciplinary platform supporting research and integrated education in health law, data protection and medical ethics. And last but not least, Dr. Brendan van Alsenoy from the European Data Protection Supervisor, who is acting head of unit for policy and legislative consultation at the EDPS. So in terms of our expertise and our contributions, we're heavily coming from a data protection regulatory space. And I'd like to kind of start off with a brief discussion of this document here, which is the joint opinion of the European Data Protection Board and the Supervisor in 2022 on the proposal for the EHDS. So this was the considered view of the collected data protection supervisory authorities on what the proposal looked like in 2022. And I suppose for our discussions, it really kind of forms a jumping off point for where are we now, reflecting on the opinion then, and where is the EHDS now in terms of implementation and development, which I think was the phase that we were described as being in this morning's first keynote. And what I would say, first of all, is that the joint opinion was very welcoming of the EHDS. It welcomed in particular that the processing of personal data is recognised as falling within the GDPR, that personal electronic health data is within that context. And the opinion noted that in order to succeed, what the EHDS would need to do, both legislatively and in terms of its implementation, will be to provide a robust legal basis for the processing of personal data, strong data governance mechanisms, and then effective safeguards for the rights and interests of natural persons, which of course is the fundamental starting point for data protection supervisors, is the protection of the right of protection of personal data undergoing processing as set out in the Charter of Fundamental Rights. And I think a strong quote from the opinion states that the EHDS should serve as an example of transparency, effective accountability, and proper balance between the interests of the individual data subjects and the shared interest of society as a whole. So that's, I suppose, summing up the positives from the opinion. The opinion, of course, raised some concerns at the time, some of which have been addressed in the final iteration of the regulation, some of which remain to be implemented or discussed through implementing acts, through member state law and the interaction. Things like the interaction and engagement, collaboration and cooperation between the various designated bodies under the EHDS and the Data Protection Supervisory Authority and the European Data Protection Board. Issues around the localization of data. Should data remain in Europe? How will cross-border access work? The ability of the HDAB to carry out assessments of the lawfulness of data processing, which underpins the granting of access. the interaction of secondary processing with member state law, and in particular, and I was very struck by this morning's discussion on wellness apps, the joint opinion expressed some reservations about the inclusion of data from wellness apps within the overall scope of EHDS, and suggested that stringent safeguards will be required, including the reliance on individual consent. And I think the discussions in the joint opinion will greatly influence our views in our subsequent conversations. Just some, I suppose, key concepts and things to bear in mind from the GDPR, and apologies, I don't have a monitor in front of me, so I'm going to have to look over my shoulder. So we are reminded that personal data shall be processed lawfully, fairly, and in a transparent manner according to the GDPR. And I think in health data, in which I've been involved for a long time, the one that really sticks out is that middle one of fairness, which is at the end of the day an ethical concept, and applies very neatly, I think, in the healthcare community, which is ultimately founded on ethical behaviours, but we will look into that as we discuss the EHDS. Purpose limitation and data minimisation, again, key principles of the GDPR, which we find embedded into the EHDS, but perhaps with some slight variations, which we will try to explore. Data accuracy, integrity, confidentiality, again, key themes in the GDPR. Accuracy, of course, for health data, absolutely imperative, given the possibility for adverse patient outcomes arising from inaccurate data. And integrity and confidentiality and security, again, key components of data protection law, and very often what people think of as the nuts and bolts, rather than the philosophical elements of data protection. It's really what keeps the data secure, stops hacking, stops breaches, stops unlawful processing. Accountability, of course, which is the underpinning principle of the GDPR. How are organisations held to account? How do they demonstrate accountability? And I think that comes through in EHDS as well. The risk-based approach, which at the end of the day, the GDPR establishes that the right to data protection is not absolute and must be balanced against other rights. And I think in the EHDS that's a very interesting balance, because we're now talking about moving the health data of individuals into a space where the public interest is now weighed against the privacy rights and data protection rights of the individual. So everything in the data protection space comes from that risk-based approach and understanding the pros and cons for the various parties and their interests. And of course, data subject rights, the GDPR expands upon the right, the general right to the protection of personal data in the Charter in some very specific ways, which are again reflected but slightly deviated in the EHDS, including the right to transparent information and access, rectification and erasure, and restriction and objection to processing. And finally, before handing over to my colleague Georgetta, new slide. The European Data Protection Board, as some of you may be aware, recently published for public consultation its guidelines on scientific research in the GDPR. This is available for public consultation on the EDPB website, and I would welcome everyone in the audience to have a look at these guidelines, and please make your thoughts known through the public consultation, because having worked on these guidelines, we want them to be as meaningful and effective for researchers and other people in the field as possible. So please do check that out. But the guidelines touch upon a lot of what is pertinent to the EHDS and to our conversation today. For example, the very concept of processing of personal data for scientific research purposes within data protection law, how the principles of data protection are applied within the context of research, lawfulness of processing within the context of research, transparency measures, and very interesting conversations. And I'm conscious of the panel here just before lunch talking about re-consenting and data repositories and things like that. So the guidelines get into conversation about modalities of consent management, how to keep in touch with patients over time to make sure that they're made aware of changes to health data they may have provided for a particular purpose. I think will be of great interest when we look forward into how data can come into the EHDS. Again, data subject rights and the attribution of responsibility, so controller and processor, who was the data controller, who was the processor. The joint opinion noted that the EHDS uses slightly different terminology, a data holder, a data user, and at what point these organizations may be data controllers for the purposes of the GDPR is worth investigating. And again, appropriate safeguards under Article 89 GDPR, so the processing of personal data for scientific research must be done in accordance with appropriate safeguards to protect the rights and freedoms of individuals, which I think quite mirrors, and we'll see in the conversation, what the EHDS requires. So I'm going to hand over to my colleague Georgietta, who's going to take you through a case study example of where Ireland is in terms of EHDS preparation. I think very interesting, following on from the previous speaker, looking at where Belgium is. Thank you.
Well, hi everyone. Thank you so much for being today with us. While David finds it exciting to look at us, I probably wouldn't have come with our presentation after the Belgium, in fairness, because they're ideal and it seems like it's the dream come true. I'll just bring a few remarks that were there in 2024. The European Commission called Ireland as being a beginner when it comes to European health records, and as well our own Department of Health said a clear outlier. So we still have a lot to go when it comes to where our electronic health records will be coming. But from the outset, I want to emphasize that the DPC's role in EHDS is not to hinder progress. It's to ensure that we unlock the value of the health data and that we do so in a way that maintains the public trust. So these objectives are not in conflict, but getting the underlying framework right is critically important. So as David mentioned earlier, I'll bring to you a brand new piece of evidence, which is the health data at IE. And it's a report that was published last month in March 2026, and it's the readiness assessment published by our Health Information Quality Assurance. So what they have done, they've surveyed 16 of our Ireland's key health data holders across 21 data sets. And this will kind of give us a great picture to see where Ireland actually stands. Is it this one? Sorry. Great, so let me set the scene first. So the EHDS regulation entered into force in March 2025, as you know, and now Ireland has an obligation to establish at least one health data access body. And this will be the first time Ireland has ever had a national health data linkage authority. And this is a landmark moment, and it's not only ours, probably other member states are in the same boat as us. Now, when we look at what else we need to do, it's as well as the implementing acts need to be published. And in terms of our national legislation, we need to promote the Health Information Bill, which kind of gives us a legal basis to create that electronic health records and to transfer the data. So that's where we currently are. So we still have a bit to go when it comes to even starting the process altogether. Now, in terms of we do have the Health Data at IE project, which is funded by EU for Health, and it's led by our Department of Health, HIQA, and our Health Research Board. So this is the vehicle that will create data infrastructures, and those are the sets that they will be looking at. So they'll be looking at the National Health Data Set Catalogue, the secure processing environments, training for data holders and the public. So there's quite a lot of work to be done, but we're getting there. Now, I'd like to bring a few statistics here. Knowledge is ahead of action. So 87% of this key data holders, they know EHDS is coming, yet 62% are only at average readiness to actually deliver the data. So 3 in 4 organizations, they have no way of recording whether a patient objects to their data being used for health research. So this is a gap that needs to be fixing before the EHDS comes into play, before the HDAP opens its doors. A third of our data holders have never linked their data sets to another. So again, we will need to work on this capability to ensure that EHDS will work properly. Now, I would like to just give you an understanding where we are in terms of linkage and the identifiers that are being used in our hospitals. So we have, some are using the date of birth, some are using first names, individual health identifier, PPSN, which is our national identifier as well. So there are different sets, and that's where we will see the challenge in making sure that we bring this fragmentation and we have a cohesive, and we can link the data sets accordingly. So what do data holders need the most? Legal certainty, technical tools. In terms of data protection, we notice anonymization being quite one that's being flagged. And why is this being flagged? It's being said as being it's often highly manual, it's time consuming, it's resource intensive. Staff preparing the data frequently lack that sufficient legal knowledge and formal anonymization training. And as well, because of these skill gaps and the fear for future re-identification, this can lead to restrictive data sharing terms, such as preventing that data linkage because they're too afraid to anonymize, then they'll prefer to stop there. On the EHDS, there are other new obligations that are laying here on top of the data protection consideration. So we will have to look at the opt-out system, the open data upload obligation. There's a 3 months data submission window, and the annual data quality label. And as you might have seen previously, only 23% of our data holders have a data quality strategy in place. So these are not abstract concerns. They really translate directly into whether a HDAP can function. And our work in the DPC will be to assist HDAP to navigate these challenges. So let me close with 3 set of points. What the DPC's role is, where guidance is urgently needed, and what the system as a whole needs. So on our role, EHDS does not regulate GDPR. The DPC remains the competent authority for data protection compliance across all health data use, primary and secondary. So EHDS under Article 41 also makes us a market surveillance authority for electronic health record systems, a new responsibility we have to prepare for. And as Irish health data begins to flow through health data at the EU, our involvement in EU supervisory cooperation becomes operationally critical. So on the guidance gap, we will have to look at making consistent asks from data holders to assess what is anonymization. So what standard is sufficient? Who validates it? So we as the DPC will have to work with HDAP and to create clear guidelines on what's really required. And we'll have to look as well as the opt-out system, which will be designed in cooperation with ourselves. And the HDAP, that's a challenge as well as not only for us, it's for all the member states. Finally, all the system asks from the readiness report are the ones that the DPC supports. So we have to enact the Health Information Bill. We have to mandate a universal identifier in order to link all the data. We need to build a national quality framework and to invest in peer support and training for all the data holders. So my closing message for this panel is EHDS will only deliver in promise if data protection is built in, it's not bolted in. And we are a partner in it and not a barrier. I think we're done.
Thanks very much, Georgetta. And yeah, I'm actually just dreading the workload that we still have to do in Ireland. One of the weird anomalies we have in Ireland is that we don't have a national identification number. So very, very difficult for us to envisage how this is going to work. I might just hand over to my other panelists, maybe just for a brief opening remark. Perhaps tell us a little bit about your own area of work and what you consider to be maybe the key touch points, challenges, difficulties between EHDS and data protection law. Anna Maria, I might hand over to you first. Thanks.
Thank you very much, David. First of all, thank you very much to David and Georgetta for inviting me to this panel session. I'm very pleased to be here today, especially because I have the opportunity to meet again with my dear colleagues from VOB, my colleague Yao, who is here, hi, and my colleague Ashwini. We have been implementing EU-funded projects together, which were very successful. So yeah, I'm very pleased to be here again. So I would say that this is a very good moment to have this discussion because we are moving from legislation to implementation, and this is where the real questions begin, like how EHDS and GDPR will function together in practice, how we will share responsibilities, and how we will ensure strong safeguards and support innovation. So I will say something about situation in Croatia. You introduced me at the beginning, so I'm not going to introduce myself again. But as well, I'm a member of Croatian working group. We work on development of Croatian national law on implementation of EHDS. So I'm working very closely to develop this law with Ministry of Health. This is now my focus. I'm very pleased to be here today to discuss about interplay between EHDS and GDPR with very distinguished and great experts in this topic. So in Croatia, we are not starting from zero. We are not starting from scratch. We have implemented already Croatian National Information System for exchanging of health data. And already for years, we have been exchanging in everyday healthcare health data through this information system. So for example, if you go to one hospital in Croatia and you take some medical exams and then you go to another hospital, you don't need to take papers with you, everything will be in the system. As well, the same thing with e-prescriptions and some other other health data. On top of that, we as well have this portal, health data portal, where patients can already access to their some of their electronic health data, like e-prescriptions, lab results, medical findings, discharge letters, and others. As well, they can use this portal to restrict access to their data. And third thing that we have at the international level, our Croatian health medical system, information system is part of my health system, where we are exchanging at international level data like patient summaries and e-prescriptions. So it is fair to say that we have, let's say, operational basis for EHDS in Croatia. It is not, of course, perfect. It has its flaws. It needs to be definitely expanded with more functionalities. It needs to be made more robust and resilient to cyber attacks and so on. But we have something. We are not starting from scratch. So the main challenge in Croatia, maybe I think in many other countries, will be that many healthcare institutions don't have systems like they have outdated systems that are not interoperable with EHD system in Croatia with Croatian Health Information System, but we are working on it. So this is like, let's say, the first challenge that we are facing. And the second challenge I would say that we are facing, it's like to make sure that all the stakeholders are aware that EHDS is not replacing GDPR. So all the obligations from GDPR remain for all the organizations. GDPR rights remain. And let's say that EHDS is, let's say, operational layer on top of GDPR, on top of existing rights and on top of existing obligations for organizations.
No, thanks very much. That really actually rings true with the Irish experience as well. And I think that points that's made in the EHDS and the recitals that it aims to complement the GDPR is well made. Brendan, might hand over to you for some opening remarks.
Thank you very much, David, and also thank you very much to you both for the kind invitation. Basically, a brief word about myself first is my unit is responsible for preparing opinions on behalf of the European Data Protection Supervisor whenever there's a legislative proposal, whether it's a directive or a regulation that has an impact on the processing of personal data. And in principle, we issue these opinions by ourselves, but sometimes when a case of particular importance, such as with the European health data space, we issue it together with our colleagues in the EDPB, and David gave you a very good overview of our view. Now, it's important to note that the legislative story doesn't quite end there, in the sense that the EHDS provides for north of 30 implementing acts, which are right now in the pipeline, and for which will also still be consulted. And in addition, there is also a role for the EDPS later on, this is not for my team, but for another team, when it comes to the supervision, particularly when it comes to the activities of the Commission and its role as processor in supporting cross-border infrastructure for primary and secondary use. It's mainly doing this in the role of a processor, but there's also the possibility for the member states' national contact points that ask the Commission actually to set up a secure processing environment in the context of secondary use. So we've talked a lot about interplay, and there's definitely a lot of very welcome clarifications, I think, in the EHDS regulations final text about what the relationship is between data protection law and the EHDS regulation. I do think, though, that there are still going to be some, there's some work ahead to kind of navigate exactly where does one end and the other pick up. And I think this is true both, horizontally between the GDPR and the EHDS regulation. I think it's very good that the regulation provides also the possibility to actually use some of the same platforms to enable exercise of both rights. I think at least from individuals' perspectives that might make things easier. But it's also vertically in terms of what's provided in the HD regulation, what's going to be further specified at member state level, and where do the two leave off. And this is also relevant from the perspective of enforcement of individuals' rights, because of course there is still the competence of DPAs, but there are also new authorities being established that also have some oversight capabilities, and how these two are going to relate to each other in practice, I think is going to be interesting, necessary, perhaps time-consuming at first, but hopefully we'll get there. So I think at the end of the day, the main challenge is how do we actually manage to keep things simple and transparent for individuals, notwithstanding this complex and intricate framework.
Thanks very much, Brendan. And Marta, as the non-regulator on the panel, you might have a different insight into what your thoughts and views are on the HDS.
I just wanted to start exactly from this line that I'm super happy to be surrounded by really expert in really practicing the GDPR and having this perspective on the HDS. I come from looking at the HDS since the publication of proposal, or even a little bit before, so since 2022. I was mentioning before the panel that there were times that I really remembered by heart the numbers of the regulations, so I really come rather from the HDS. And first I looked at it from the perspective of really a Polish think tank where we were trying to practically think about data governance in healthcare, and we were discussing things with really people in the health industry. But then I moved to the commission where I, for just 6 months as a trainee, worked really on the proposal, and we were then, this was the time when we were discussing opt-in or opt-out or any other different ideas that were in. So it was also interesting to see it from the perspective of the regulator and the discussions between Parliament and the Council and the Commission, so it was really insightful. And then I moved a little bit, let's say, outside, really also outside of Brussels, where I first worked for a broader data spaces ecosystem for Data Spaces Support Center project, so in the academia in KU Leuven. And now since February, I moved to even like more, let's say, abstract discussions, because I started PhD in Ghent on human digital twins, so really like connecting all of the topics also regarding data from other data spaces plus data from EHDS towards something really maybe a little bit science fiction, but I believe that it's not going to be that case anymore. And because of my different background, I would like to maybe, regarding the touch point and the challenge, do a little bit of a step back to look at something that we did when I was still working in Center for IT and IP Law. We were trying to make sense of all the existing regulations and the regulatory framework for data spaces. And we developed some sort of classification or categorization of the regulatory framework in the EU for data, which is in two kind of axes. One is the protection regime and the other is the access regime. The protection regime is obviously the GDPR because it's about safeguarding fundamental rights, the personal autonomy, different private interests. So I'm kind of referring a little bit to the topic of today's panel. I would say also different IP rights and trade secrets whenever applicable for data sets, but of course it's a bit of a different story, but I will also touch upon that briefly. And then the access regime, therefore, I believe the DGA, a bit of Data Act, Open Data Directive, so all the frameworks that really work towards facilitating the use and reuse of data. And now EHDS is a very interesting framework which technically turns towards access, but it sits kind of in between of protection and access. So really, I believe that the touch point or tension maybe, or the challenge, I don't know what's the best word to use it, it's really this balance. And of course, we talk about balancing. Balancing is like a word that it's maybe at some point it doesn't make any sense. But I really think that the most important challenge that actually plays out on very different levels throughout the regulation, it's about how do we make sure that the, let's say, private interests, which are in the protection regime, so the not only GDPR, but also IP rights and trade secrets, how they are balanced with really this public interest towards which we are striving for in the HDS. And this is, as I said, in different levels. So the first one is really the general infrastructural level. And how do we make sure that the strive for interoperability really doesn't prevent or really rather supports the data subject, the protection of the data subject's rights rather than prevents. And what I mean by that is the entire kind of structure of the demarcation line between EU competence in harmonization and the member states and how they overlap in the regulation and how it will impact the actual implementation. Because like sometimes we can see that in certain aspects of the HDS, it's within the same aspect that we have both EU and member states competence and how it will evolve. Also looking at the health data access bodies and how it will impact them and how different will be the interpretation of certain rules between one country and another, because one very interesting provision that I sometimes forget about, and I had to look at it before today's panel, is that each HDAP will have to also take into account the risks. Therefore, the risks for public order, which may go towards, let's say, rather more public morality and stuff like that, which will be very different among member states. So really, we, on the one hand, we want one common European data space, but how do we make sure there will be not multiple common European data spaces? So I'm referring a bit to what you said about interoperability, which is a problem within one country, but here I'm trying to look a little bit more broader. And then what you also said about the rights and responsibilities and what I mentioned before, we have to look at the entire kind of ecosystem in which the EHDS is working right now. So it's not only interplay with GDPR, but also all the other existing frameworks. So how do we make sure that we actually understand how they interact with each other, and that still the data subject or natural person or however the individual, it's protected in a good way.
Yeah, thanks so much, Marta. I think there's so much in that. I really like that sort of protection, access. You know, those kind of different touch points of the tension that we're looking at, and I think you know what you're talking about there about the different frameworks, and we're going to talk about like the interaction between different data spaces, but the entire inter-regulatory space, you know, between Data Governance Act, Data Act, Digital Service AI Act, you know, there's so much we could go into. I don't think we have time to, but I think you're dead right. That's what needs to be borne in mind all the way through this and in that interaction between different regulatory authorities. I know, Georgetta, you gave us a very good rundown of where we are in Ireland earlier. Maybe just a quick word maybe in response to any of the others, or what you think the key challenge is.
Yeah, like you've all seen our challenges, and I know it won't be a quick one to turn around. We've some groundwork to do at the infrastructure, the legal basis. But in fairness, we're there. So myself and David were there to assist the Department of Health to drive this through. So what our unit does, just to give us an indication, so we're not there just to issue fines. We're there to assist. So because we're supervision and consultation, that means that We assist the departments, not necessarily only Department of Health. We assist the health sector in with major issues that they might have in terms of data protection compliance. We also review DPIAs, not only the ones that are mandatory. If an organization wants to come to us, we'll definitely look at it and we'll bring our observation, and as well as legislative proposals. So that's where it comes, the Health Information Bill comes, and that's where we were consulted to ensure that appropriate safeguards are in place when these legislative proposals come in place. So we've been as well consulted by the Department of Health on their work on the opt-out system and how will that work in practice, and there's still debates there and there's still clarifications which need to be brought along. So we just want to make sure that we are there to support, and all the data protection authorities are there to support, that this goes great when it will run on its feet. So we're more than happy to assist if any health researchers which has any issues with it. So I think that's my take here.
Yeah, no, thanks very much. And I think that's really important to bear in mind that very often GDPR is kind of seen as the bad guy, the barrier, but it is also there to facilitate the use of data very much. So what we're going to try to do in the next while is dive into kind of key areas across both primary and secondary use of health data in EHDS from the point of view of data protection, and going straight to kind of data protection rights and the right of access. One of the aims, obviously, of the EHDS is to improve the access for the individual to and the control over their own data. The regulation provides rights that in many ways mirror what the GDPR does in terms of access rectification restriction. However, the joint opinion highlighted a potential risk in operating parallel systems. Anna Maria, I might come to you first on that one. How do you see this playing out in terms of the current experience of how access works in the healthcare setting?
Thank you. This is really a great question. I would say, from my practical experience, that there are some real risks of having EHDS and GDPR rights in parallel, as it was pointed in EDPS and EDPB joint opinion. There will, let's say, some practical complexities. Because, again, I need to highlight GDPR rights remain, but EHDS gives to individuals, to patients, additional rights. So let's start with right to access. If you, under EHDS, want to exercise your right to access, you will exercise it through some online portal, and you will get immediate free access or to online portal or application, and you will access it and you will see your discharge letters, lab test results, and medical other results, and so on. But if you want to exercise, for example, your GDPR rights, if you want to exercise your right from Article 15 of the GDPR, and if you want to get all the information from data controller, from subparagraphs A to H, like recipients of your personal data, data retention periods, categories of data that are being processed, automatic processing of personal data, and so on, then you're exercising your GDPR rights. So, for example, if I have been to hospital for some exams, and then I want to know what kind of data this hospital have about me, I want to access to this information, I will need to send requests to DPO of the hospital, and luckily within 1 month I will receive all the information from Article 15 of the GDPR. If I want copy of my data, again, I need to turn to data controller, so in this case, hospital, to receive all the copy of my personal data. So let's say these two rights, right to access under EHDS and GDPR, are related, but they differ in scope, the practical delivery, in channel, in speed. And I see, I am talking about situation in Croatia, that people will be definitely confused. And they will be maybe at first angry because they will think, okay, my rights are denied, I didn't succeed to exercise my rights, while they didn't use the proper channel, let's say like that, to exercise their rights. So this might create at first confusion. It will be at first, but we will deal with this and we will solve this issue, I'm sure. Then the second harder issue is definitely right to rectification. when we talk about rectification of personal data, rectification of health data is not the same like asking for rectification of data in customer database. So it is very important for health data to remain its integrity, for the safety of patients, for the accountability, for continuity of treatment. So I'm talking from my practical experience from creation DPA. There were like people who were asking, I want to rectify my wrong diagnosis under Article 16 of the GDPR. So you cannot overwrite your diagnosis, let's say your historical records. So the right model here is to add supplementary information, to add updated information, but not to override the historical record, because in future this may cause problems, or it can put into danger patients' health and safety and everything related to health of the patient. So when we talk about EHDS, okay, yeah, of course, patient has the right to ask for rectification in a way that he will send requests through EHDS system. And this request will be forwarded to original creator of the information, to original data controller, who will then assess whether this information is incorrect and needs to be rectified. So we are not talking about self-editing, like patient can enter into the system and self-edit the health records. So, the next thing, which is very important here, it was highlighted in the opinion of EDP, DPS joint opinion, that one thing needs to be very clear here: who is responsible to, let's say, make sure that rectification is made through interconnected system. So it needs to be carefully done through all the system. So this is like the next, let's say, concern: who is responsible for rectification through interconnected system, to make sure that it is very, let's say, that it is done, carried through effectively. So yeah, there are some, let's say, rights that are overlapping, but we will deal with this, I'm sure.
Yeah, I think that really speaks to the, I suppose, the governance and then also the transparency, because I can see the risk you're highlighting there, where an individual might exercise right of rectification under GDPR with multiple healthcare providers, also using the EHDS facility to supplement their electronic health record, and tying that all together, I suppose, and ensuring that there is fundamentally an accurate record going forward will require that level of interaction. You mentioned Article 15 of the GDPR, which provides the right to access. One of the possible conflicts or tensions that we've identified in that is the way in which the EHDS allows the individual, the natural person, to get information regarding the healthcare practitioner themselves. So the individual who is involved in their care and treatment, who is a third party essentially. And it treats it a little bit differently. So it allows for the member state to vary how the information is provided in order to provide some perhaps necessary protections. But Article 15.4 of the GDPR provides a different way of looking at this. So if information regarding the healthcare provider would adversely affect that person, affect their rights and freedoms. I'll go to you, Georgetta, on this. How do we see that balancing out? Because from our point of view as data protection authorities, the doctor, the nurse, that person is also an individual with data protection rights.
Yeah, exactly, David. So, but when we're looking at Article 15.4 of the GDPR, it says that the right to obtain a copy of personal data cannot affect the rights and freedoms of others. But there has to be a balancing test as well when it comes to what adverse consequences might be on the individuals. So in this instances, for example, Article 9 kind of leaves a maneuver for member states to provide restrictions when it may be exceptional cases like vital interest or the rights of the health professional or the care. Now, it will be interesting to see how this lays out, because from what Article 9 really states, it's automatic notification on any access. So how can this be implemented, and how can you ensure that you are really giving enough safeguards to the individuals, like ensuring their vital interests are not being infringed. But I want to bring up to a case that's been kind of ruling on this situation. It's the Pankey case, which probably people know it by now, where an individual wanted to know the access logs of he was a member of a bank, and he wanted to know the access logs, the dates that people were looking at his records, and as well as the employees, the names of the employees. So this ruling kind of, while he got the logs and so on, he wasn't kind of entitled to receive the names of the employees. And the ruling kind of states that the employees who look at the data under the instructions of the employers are not considered recipients under the GDPR. So you kind of need to have a kind of a strong reason to request those names, whereas EHDS clearly gives that automatic right for ourselves as individuals to know who accessed our data through an automatic notification on any access. So it will be interesting to see how this will tease out and how it will play.
Yeah, I can definitely actually anticipate complaints from healthcare workers to us regarding the processing of their personal data, where it is released to individuals. And we've seen cases where healthcare workers have been targeted outside their work, targeted at home because of a personal grievance. And at the end of the day, all those people have individual rights. I think in looking at how the member state law implements these protections will be key in understanding how we can manage that situation. I think the legitimate expectation of privacy, I think, maybe plays into this as well. That for senior clinicians, for consultant surgeons, perhaps there's an expectation that person's name should be known. But I suppose that once you go down the hierarchy of the hospital or the healthcare provider, is there an expectation of knowledge, that the individual, that the patient should know the names of all the people involved in their care and treatment? I don't know. Does anyone have any other thoughts on that question? Or we can.
No, I mean, I think it's a very good question also in terms of and it's very interesting to hear about, again, exactly these practical experiences. I think when I looked at the HDX, the text of the regulation, I had the impression that, well, interestingly, I think it came out before the Pankey case, so it's also interesting whether or not that judgment might have, tipped the scale slightly differently. But I think, the idea here is that because it's such sensitive data, they really wanted to make sure that individuals are able to kind of understand who is accessing my data and will be able to make the connection and have the reassurance that there is some connection with their healthcare treatment, and they don't want to run the risk that maybe somebody in the hospital is looking in, because those are also very often the stories that come out where somebody's been looking into medical records that they shouldn't have been looking into. And so I think here it does shift the presumption. I think also, when it's in the same hospital and it's staffed within the same hospital, that's one thing. But when we're talking about, separate data controllers asking across, well, then normally you would have the right to the identity of those controllers anyway. I guess, again, it really comes down to, at what level of the organization and what's the relationship with the patient and what degree of visibility. But for me, the HDS is kind of clear in saying, okay, the default presumption is different than it is in general data protection law. There will be a right to know, and then the question is indeed how do you articulate the exceptional circumstances in which there might be an overriding interest to limit. So I think that's definitely going to be tricky to navigate.
Yeah, I think we won't know until we see the complaints come in. Brendan, I might stick with you for a moment, because we were talking previously about the right that the regulation provides to restrict the access. So, we're talking about the access that health professionals will make, which can be restricted by the individual, and to essentially to opt out of their data being involved in sharing for primary use. Now, again, this can be varied at member state level regarding the specific rules, the safeguards and exemptions. We were talking previously about in the cross-border contexts, and I think the panel before lunchtime was talking about kind of discrepancies between member states. But what impacts could this have on medical practitioners on their access to data if this is implemented in varied ways across member states?
Yeah, so I think as you highlight, it was one of the key points of concern in the joint opinion, because the GDPR, which is our starting point, really provides for the possibility for member states to introduce additional conditions, limitations when it comes to processing of health data. And so a lot of member states do have established traditions which also reflect their national cultural sensitivities and identities. And if you look at how the legislator ultimately tried to navigate the rights of individuals to restrict, it's really, actually does it in a double way. It's not just, there's this principle, you will have the right to restrict access to by other healthcare professionals. If you do that, you should be properly informed that this may have actually an impact on the provision of your care. And actually, there's also the possibility, when it's really a life-threatening situation, basically for medical practitioners to break the glass and still have access. And for me, this was not entirely surprising. In an earlier life, I was also, researching in the Belgian e-health context, and this all seemed quite familiar. But then there's also this other possibility of a restriction or basically an opt-out of access through data access services as a whole. And so I was a little bit confused as I was trying to read through the recitals. Also, is there a break to glass or is there an absolute opt-out? And even in the case of the absolute opt-out, there might then actually still be a break to glass, although it's kind of hard to see how that might work technically in practice. But basically, there is both for the right to restriction, but not only for the right to restriction, quite a few areas where there is the possibility for further member state specifications. And I think this will have operational implications, at least when we're looking at patients visiting other medical practitioners in a cross-border context. I think it will also be, probably for the medical practitioners, they might have an expectancy to be able to access certain data in accordance with their national system. How is this going to relate to potentially restrictions that individuals are allowed to set under their national country legislation? And I think at the end of the day, it just kind of shows, what we have wound up with is, again, I think a fairly intricate compromise in terms of where do we give, patient autonomy, where do we leave member state autonomy, and how do we ultimately wind up with a system that works efficiently and effectively in a cross-border context?
No, thanks very much. I think when we talked about the restriction of access and opt-out in the Irish context in terms of negotiating the Irish legislation, there was very strong representations from many in the medical community that this should not in fact be implemented, that it should be entirely mandatory, and that in fact offering an opt-out in a sense undermines the public interest argument, that if you're arguing that the EHDS is strongly in the public interest, then perhaps it should be mandatory. But we are where we are, and I think it'll be an interesting one to negotiate. Following on from that, Marta, I might come to you to sort of in a higher level sense in terms of the opt-in, the opt-out, the inclusion in EHDS. One of the key requirements, as I mentioned at the start of the GDPR, is fairness of processing, which is, as I said, kind of embeds an ethical consideration. From your own research and your thinking, what are the ethical implications in the rights, in relation to the rights of the individual to engage with EHDS in terms of their, perhaps the ability to moderate your own digital engagement, but as well the flip side, kind of the risk of digital exclusion of vulnerable members of society, and how do you see this playing out?
Yeah, thank you. Just maybe to add to what Brennan was saying, because that's, I think, what's also interesting in the context of restriction, etc. It's like we have to play out the patient autonomy, member state autonomy, but also how the responsibilities in terms of providing like a relevant healthcare treatment and diagnosis, how it will evolve in the general, like when we are giving patient more autonomy, how it impacts the responsibility of the doctor. So I think that's, in general, that's a very interesting discussion. I think it's quite related to what I wanted to talk about. Again, I will be the person who will today zoom out and look at the ethical, theoretical questions, but bear with me. I think I was really looking first at fairness as a GDPR principle, and I was thinking indeed that comparing to the other, like for example, lawfulness or transparency is one of the most ambiguous, if not the most ambiguous or like really enigmatic principle, because it's like in between of all of them. It touches upon a little bit of everything. So in order to look at the criteria, I looked into EDPB guidelines on dark patterns actually, and I don't know if it's completely translatable to what I'm talking about, but I think it gives us interesting insights of like how do we make sure that processing is fair. And there were a couple of interesting elements like interaction, that a data subject has to be able to communicate with controller and effectively exercise their rights. The autonomy, so the highest possible level of control over the use of the data. The respect for the rights, so that the controller has to make sure that the processing does not interfere with fundamental rights, so I guess not only the privacy, but also the broader fundamental rights perspective. And indeed the ethical dimension, so that the controller has to consider a broader impact of processing on individuals' dignity and other rights. And I was thinking recently, it's something that I was inspired with when I got to know a bit more about the research done by Human Rights Center in Ghent as well. Let's think about the EHDS for a moment, not as a regulation only, but as a general digital public infrastructure to which we will have access or not, like access to public services in general, because it is some sort of public service to access one's data, etc. So the question here, and I think it relates well to fairness, it's whether the fairness as a principle, as a GDPR principle, requires that the rights should be exercised also potentially offline, because what the EHDS is doing, again, as a digital public infrastructure, as a public service, it's that it kind of shifts towards only online possibility of exercising the rights. And this goes into the broader discussion, academic for now, but I know that there is a project that works on like the really discussion on right not to use internet or right to be offline. And I remember when I saw this, I got super inspired and I wanted to kind of investigate whether EHDS also goes into this direction. And when you look at the provisions on primary use, we see that the registration of priority categories of personal electronic health data will have to be registered in an European Electronic Health Exchange. I always forget how to exactly say that, but you know what I mean, the Electronic Health Records format. And I was thinking, okay, if that's the requirement, if the member states or other healthcare providers will have to, like, they are obliged to have this in the digital format, they don't have anymore the obligation to actually have it in a non-digital formats, because the obligation is actually for having it online. So that's one thing. And the other, it's when we look at the access provisions, we see that you can only access through the kind of proxy services, right? Like, so, and even if you have the vulnerable groups, there's the provision that, okay, they will have some special, that for them, this access services will have to be accessible, etc. But again, there is no clarity in terms of whether there will be some sort of option to do it without the use of digital services or offline. And it's the same, for secondaries it's even worse, because they only say that it has to be some sort of mechanism. So again, probably it will depend on member states, but reading this and connecting to this broader academic discussions I've been following, I was just wondering, where do we go? Can we still provide, like, of course, we can look at other fundamental rights. We can look at GDPR. Maybe GDPR it's enough. Maybe it's enough to like access the health data using the GDPR subject rights. But maybe when we look at the entire shift towards the digitalization of public services, maybe it's not enough anymore. Maybe we need to recognize a new kind of right to, again, to be offline, or maybe we can derive it from existing ones. It's still an ongoing discussion, but I think this will be an important consideration regarding like really ethical aspects of and the ethical impact of EHDS, and specifically let's say, the interpretation of fairness in that context.
No, thanks very much. I think that's it's a really interesting area, and like from our point of view as regulators, remembering that each individual is an individual data subject. We can't en masse dispense with the rights of the individual, you know, as we've learned to our cost in numerous cases before the CJEU. You know, we can't collectively as a society decide that, well, this right doesn't matter anymore and force people into a particular space. Conscious of time, so we might jump on into discussing secondary use at this time. And Brendan, I might just come back to you to give us maybe an update on some, because I think relevant to our conversation on the permitted purposes of secondary use, besides EHDS, there have been recent developments in the legislative space on the concept of scientific research, as I mentioned earlier on, looking at the digital omnibus, proposed amendments of the clinical trials regulation, and of course the EDPB's guidelines. In terms of secondary use for scientific research and the other purposes in the EHDS, where do you see the interplay between these sort of evolving spaces?
Definitely a good question. When we think about, you know, scientific research, we think about something which, you know, contributes to society's knowledge, well-being, etc. And that, of course, is very, very important also in the health space. One of the reasons why we also issued with the EDPB guidance on the notion of scientific research, and the idea that the GDPR has, because of this added societal value, it should be made easier. And it translates into a number of provisions. There's a presumption of compatibility. There are exceptions from duty to inform. And there are also, you know, notions of broad consent, I think were alluded to earlier, and the possibility actually for union or member state law to specify specifically also for special categories of data like health data, how to enable use for scientific research purposes. And so actually what the EHDS regulation does is that it provides also for a lawful basis and exceptions within the meaning of Article 9 of the GDPR. And so it really acts as a sector-specific implementation. And I think we can welcome that it does, in fact, also provide for quite strong governance mechanisms and safeguards, you know, of technical and legal nature. And I think that's a very positive development. There are, let's say, multiple reasons for which electronic health data can be used for secondary purposes, or rather there are multiple purposes outlined in the EHDS regulations, and only one of them is scientific research. The other ones do also have, let's say, a strong public interest component, although some of them might be articulated in a more open nature than others. But still, scientific research is one of them. And just like the GDPR, EHDS regulation makes clear that it's, you know, not limited to purely academic science. There can be commercial applications. It can be linked to technological development or innovation. What the EHDS does do is it kind of brings AI in the training of algorithms explicitly in the mix, which was not the case in the GDPR yet. And then in the meantime, we have the digital omnibus proposal, which, contrary to the GDPR, actually tries to introduce a notion of scientific research. And I think maybe one of the reasons why it took the EDPB a fair amount of time to actually issue these guidance on scientific research was this lack of a definition. And, you know, sometimes I think of, you know, scientific research, you know, what's the difference between innovation and scientific research? Or innovation that is not scientific research. It's almost like, you know, the difference between art and pornography. Like, it's very hard to say it, but I know it when I see it. Nevertheless, we did try quite, you know, judiciously to articulate some of these criteria. We were happy to see some of these elements also reflected in the Commission proposal. In the end, we had some concerns about how the different elements were related to each other. Just to give you an example, you know, this element of supporting innovation, obviously, you know, there's research and development for products, which is not necessarily scientific research, whereas there is also still scientific research, which does not necessarily support product development. So where we are now is that we do have a notion of scientific research already legally embedded in the EHDS regulation, which I think is still fairly compatible with GDPR. Again, the question is how far does this stretch to AI development? And I think it's reassuring that at least in the EHDS regulation, there's still this clear qualifier of this link with public health services or devices, or, you know, there's still, let's say, a very strong component that's linked there. And of course, there are all the additional safeguards that the EHDS regulation provides, which we don't have as a starting point necessarily under the GDPR alone. And so I think that's very important to keep in mind, and how we're going to navigate, let's say, the coherence in approaches also when it comes to the reuse applications and the consistency in that regard is going to be quite interesting.
No, thanks, Brendan. And like, I remember those conversations over the last number of years on trying to pin down what the meaning of scientific research is in the GDPR, and we always kind of strongly took the view that it's not the role of data protection authorities to define what scientific research is, but that needs to come from the research community. And I think we'd be interested on the feedback that scientists in the audience might have in relation to the guidelines, because what they've provided is, I suppose, a list of kind of key indicative factors that give rise to the presumption that you're processing data for scientific research purposes. Because the more we try to get into it, the more it ran away from you, a very kind of nebulous way to think about it. At one point, I tried the thought exercise of trying to establish, could an evil scientist lawfully process personal data under the GDPR for evil science purposes? I don't think they could. I think we're safe from that now. But on the same theme, Anna Marie, I might go to you just in terms of, say, from the National Regulatory Authority, when we look at, say, when EHDS comes into play, these things like processing for development and innovation for products and services, training, testing, evaluation of algorithms, in the interaction between, HDABs, data access, data users, and the data protection supervisor, how do you see this playing out?
Yeah, with regards to a legitimate use of personal secondary data for product development, AI innovation, and so on, there are some real data protection concerns here. So EDPB and EDPS were right in their joint opinion when they warned that these processing activities for this kind of purposes can be interpreted very broadly. So from my personal experience working now in this working group, a Croatian working group on development of national law for the implementation of EHDS, I see here as my first concern that HELT data access body will, let's say, quite easily give permits for this kind of processing activities without proper assessment. So they need to have HELT data access bodies, will need to have enough legal and ethical knowledge to assess the requests they receive. And another concern that I didn't think about it, but during the first panel session today, I realized that this will be really a real concern, that these permits will be like forms. Applicants will need to fill out some forms to get permit to process personal data for secondary use. And then one of the panelists at the first panel session said, okay, these forms are going to be filled by AI, some kind of AI model systems, whatever. And then HELT access data bodies who receive these forms are going to assess it using AI tools. So this is my first concern, that we are not going to have human in the loop, not even human on the loop, that this will be something that it will be assessed by some kind of AI tools, not by real people who are going to really assess it. So HELT access data bodies to give permit for this secondary use for the development of AI and AI training and innovation and products, so on. They will need first assess whether applicants have lawful basis for processing of personal data. We need to have this in mind. So they need to have enough knowledge, expertise to assess whether there is a lawful basis under Article 6 of GDPR to process personal data. And if applicants say, okay, I have legitimate interest, then they need to document, they need to provide this legitimate interest, like documentation for this legitimate interest three-part test, and then HELT data access bodies will need to have enough knowledge to assess whether this is legitimate interest or not. So this is my first concern, but okay, maybe in other EU countries it's not like that. Maybe they have great data protection experts who will be able to do that. And in connection with lawful basis from Article 6 of the GDPR, it is, let's say, exceptions from Article 9 of GDPR. So these applicants who are asking for data for this secondary use, they will also need to prove that they are going to process this data for the purpose of a public health, for the purpose of public good. And then health access data bodies will need to assess whether this is really the case. So they will need to provide proper justification, and then health data access body will need to carry out proper assessment of this. And then again, applicants who are asking for data will need to clearly specify data sets that they are asking for. They will need to specify safeguards that are going to implement against re-identification of individuals. And in cases where they are asking for pseudonymized data, not anonymized data, they will need to give clear justification why processing of pseudonymized data, not anonymized data, is necessary to achieve the purpose. And health data access bodies will need to have enough expertise to assess all of this. So this is like, let's say, first concern.
I might come in on that first concern because it's huge. And I think I'm brought to mind of the panel this morning on wellness apps, which also talks about the huge workload that HTABs are going to have to do. And as you've just outlined there, a lot of work that data protection supervisory authorities, in fact, find very difficult, to assess through our investigative procedures, whether an adequate legitimate interest assessment, for example, has been carried out. But this on the HTAB side is a pre-approval, which may then, I can definitely see give rise to enforcement under the GDPR, where a concern arises regarding lawful processing of data.
This is my first and main concern. So,
okay.
And on the positive side, I can say something positive, but I'm fully positive. I really like EHDS. Just I'm not concerned, like very concerned. So on the positive side, like individuals now in this final adopted version of EHDS have opportunity to opt out from this secondary use. So it is very important that people have this option to opt out. Okay, I don't want that my data are used for purposes of development, AI products, innovation products, or anything similar. So it is all about, I would say, about transparency and about informed choice. If I'm informed that my personal data are going to be used for these purposes, I don't want this, and I have the possibility to opt out. So this is something positive.
And that opt-out from secondary use, of course, the monitoring and enforcement of that falls to us as the data protection supervisory authorities, so we'll have to figure out how that works. You mentioned re-identification as one of the risks there. I'd like to just talk about, Georgetta, the approach taken, and Brendan mentioned this, kind of the governance regime being quite robust and perhaps limited, as has been discussed in previous panels today, and which similar to Article 89 of the GDPR, whereby anonymized data is taken to be the default, with access then to pseudonymized data only where deemed necessary, as Anna Maria highlighted. Anonymization, pseudonymization are, I suppose, movable topics in data protection law, and here they are at the heart of EHDS. How do you think this is going to play out, and possibly with reference to recent case law?
Totally, David, and it is a very important question. And as you mentioned, Article 89 brings secondary use more robust safeguards like anonymization and pseudonymization. Now, we've seen recently, and maybe Brendan might want to jump in on this one, the Court of Justice of European Union delivered a significant judgment in the case EDPS versus SRB. And this is the first judgment in which the Court of Justice of Human Rights has explicitly confirmed that sufficiently strongly pseudonymized data may constitute personal data for the original controller but not for the recipient, who cannot reverse the pseudonymization and cannot identify data subjects by other means. Now, when I was delivering my presentation earlier, I kind of touched based on anonymization and how hard the data holders find this, and the fact that they do not have the instructions on how to achieve that result, and as well as they do not know exactly if HELT data will be anonymized. And let's be honest, genetic data might not ever be anonymized. So how do we achieve that? I'm not sure, David, but as well as I would have a question, who would look at that side? Is it the data holder? Is it the HDAB? Who will assess anonymization before it hands the data? Because it's a huge task. It is, isn't it? So I'm not sure if I have the answer. I think it's more a question.
Yeah, and I think we're looking forward to additional guidelines again from the EDPB on some of these topics, additional guidance on understanding the point in time at which, I suppose, what we've always said, you know, and sometimes anonymization can be treated in an extremely black and white manner. The reasonable likelihood of re-identification is always the test, and maybe that comes down to what the SRB case looks at, like what's available to the different parties. I don't know, Brendan, do you have any thoughts on this? Georgetta tried to push you under that bus.
Yeah, no, it's we were obviously talking about this before, and it was also like, well, this is quite a bit of a quagmire, because indeed we have this judgment, EDPS versus SRB, which outlines that, you know, personal data for me is not necessarily personal data for you. Especially if we think about it in the context of pseudonymization, where there's basically a set of technical and organizational measures that make it, you know, very, very difficult for anybody without access to those means to actually make the connection with the identified individual. And that's basically the starting point. I mean, if it's not anonymous, that being the starting point, but still the only manner in which the data would be made available in the secure processing environment. So again, I guess it's still. And what's particularly interesting, of course, is still this requirement for the applicant, who is basically, you know, in principle going to be accessing the data in the secure processing environment where it is pseudonymized, where they don't necessarily have access. There's still the requirement of having the lawful basis and demonstrating things like legitimate interest, et cetera. So I think that's, you know, again, it's one of those cases where a judgment came along during a legislative process. I think, and again, that's one of those things that still makes me also more of an enthusiast rather than very concerned on the HDS front, is that, you know, you can look at this proposal and it's really tried to, you know, this regulation ultimately did try to set a high standard, very high standard for data protection and privacy. And I think now it's going to be a question of how it plays out, and indeed whether we're going to, you know, have poor anonymization data handed over to applicants who've generated it with AI, and you know, light scrutiny, and you know, and something goes wrong very quickly, or rather whether we, you know, we manage to find that right approach, which, you know, makes it's not just a box ticking exercise, but we do, you know, enable truly beneficial public use of that data, because I do think that, you know, that was also the starting point of the regulation, that there is a value there which is simply not being tapped, and indeed GDPR is also there to enable responsible use of data. But if you don't have the fluidity that can be provided at scale by a robust, you know, governance architecture and standardized practice, and again, there's going to be a lot to learn for everybody in the process, but I think, you know, that's how we're going to scale up our game at the end of the day, and I do think it's going to be beneficial. I'm hopeful that it's going to be beneficial.
Thanks, Brendan. Marta, I might bring you in on a question that came up in our previous discussions, actually on the interface between primary and secondary use, which we've kind of gone through. So one of the permitted uses that we've identified for secondary use is what's referred to as the improvement of the delivery of care, of the optimization of treatment, and of the provision of healthcare based on the electronic health data of other natural persons, which potentially creates this interplay between primary and secondary, and potentially novel uses of health data. What are your thoughts on this in terms of the impact on individuals?
I think honestly that this is one of the most interesting provisions in the permitted uses, because everyone is really focusing on the scientific research, and then that under scientific research we have the training of algorithms, and everybody's worried how it will impact, whether commercial actors will use it, etc. But I think the other one, so I think it's the last one in Article 53, I think. So regarding the optimization of treatment for other natural persons, I think it gives even more kind of like playground for the potential commercial actors to, or somebody else to use it in an evil way, as you said before about evil scientists. So that, because for me optimization of treatment can be any type of technologies for like personalization, etc. But I think here regarding the question actually, so the connection between primary and secondary use, I don't remember the context, but I had this discussion with some practitioners that they were saying that basically they were already using other natural persons' data in the context of primary use for other people's data. So they were within their practice, they were already kind of using that to optimize the treatment for someone else. And I think here, maybe it's a bold statement what I will just say, but like what the EHDS is trying to do here, and I think it's throughout the regulation in general, is to kind of force some sort of solidarity-based approach to data sharing between patients, some sort of obligation to share the data between each other, because the only way to not to do it is to opt out from it. We already are kind of urged to kind of share the data from the default for not other natural persons optimization. Only if we opt out from it, then we will not do it. I don't know if you follow my logic, but...
No, very much so. I think it chimes in with, say, the concept of data altruism
yes.
in the Data Governance Act. And, yeah.
But then when we think about it, and when we think about, like, for example, I personally wouldn't opt out because I would like my data to be used for somebody else's help. But then the actual question is like, okay, I still can do it with regards to my data. But then what happens if actually we talk about this growing concept of, and really discussed again in academic context, of relational aspect of data, so the genetic data who are not specifically my data only, but they can be my aunt's data, they can really inform, like give some health insights about some other members, not only about family, but genetic group as such. So does EHDS actually account for that aspect in terms of opt-out? Like, for example, because in my opinion, this is exactly for this. So let's say that my genetic data are available, so then it can be used for somebody else's treatment, for other natural persons' treatment optimization. But then can I decide by myself to opt out from secondary use? Is it still secondary use? Is it how it impacts the primary? For me, everybody today during some discussions, we were saying, oh, there is a clear line between primary and secondary. And in my opinion, it's not so clear. It's, there will be some type of interplays, and I'm just wondering how it will evolve and whether at some point in the future we may rethink the mechanisms for the opt-out for the data governance to really account for this relational aspect.
Yeah, I think that's really interesting. I think, and the genetic question in data protection terms is always complex. We don't really have an answer on this idea of data that is unique to an individual, but it's also another person's data. I think there's some case law from the UK around this, but nothing that we've seen, well, certainly in Ireland. I might hand over to our audience if people are still awake out there before you get your afternoon coffee. Do we have any questions, please? Maybe. Oh yeah. Okay.
Hello.
Yes, go ahead, please.
I have a question regarding what Anna Maria said earlier. I will play here the advocate devil, not protecting the health data access bodies, but actually trying to say they will have limited budget for their activities. And then if we look at it from societal implications, I think also data users and data holders will have a role there. And here I even zoom even more to data protection officers, for instance, or champions in this. What do you think will be their role under European health data space? Do you think, because GDPR comes with the obligation to have a DPO, but European health data space doesn't come with any obligations for these stakeholders to actually have a dedicated person for the implementation in their organizations. Nevertheless, no additional money will come from this, from nowhere for each organizations. Neither health data access bodies will have actually money to cover everything you said. That is true. But it's a shared responsibility, so ethics committees will still look at this balance and safety from GDPR perspective. Is their duty to do that? Again, they might not also receive money for this. It's also the responsibility of the data users on the GDPR compliance, because it's a self-assessment type of regulations, but leads to, of course, enforcement and fines if it's not properly done. So my question is, how do you see these shared responsibilities divided between different stakeholders in the ecosystem? without really finger pointing, is someone else's fault if HDAP, for instance, put the stamps for a data permit to be issued, but things don't happen to be in practice the way it was written in the application. Thank you.
These were like 10 questions. I didn't remember them all, but yeah, great. All these questions are great. So now when we are complaining about not having enough budget and not having enough resources, I would say I'm talking now from Croatian perspective. From Croatian perspective, Croatian health data access bodies are in much better position than Croatian Data Protection Authority. We have overall 10 people. I am dealing with DSA, DMA, AI. I am dealing with all the Ds and all the As and with all what exists in the world. So I'm thinking like, okay, EHD, health data access bodies have a much bigger budgets in Croatia than Croatian Data Protection Authority, so I don't think that they're like endangered. I don't feel pity for them. So they simply don't invest enough time and energy to learn about data protection. They simply don't care. So I'm talking about situation in Croatia. I don't know about situation in other member states. So they really need to work much more to raise their level and knowledge on data protection. They need to care. So this is, they don't have problem with money, they have in Croatia a problem that they don't care. So yeah, this is my first concern. And a second thing that you mentioned, role of data protection officers will be crucial. With EHDS will become even more important than before. And this is something that we are working on in Croatian Data Protection Authority. We have developed special training program for DPOs in health sector, and we are giving them trainings to enhance their knowledge on data protection. And this is something that I see that our role as data protection authorities is very important here. This is something that needs to be done by us, and we are, let's say, working on it. And of course, the role of Digital Health Authority is going to be very important in all this, let's say, EHDS ecosystem, because in Croatia, people don't trust a lot to public authorities, don't trust to, let's say, system. And we will have, I think that in Croatia, to have successful implementation of EHDS, it will be very important to educate citizens. And this will be, the major role here will play a Digital Health Authority, who will need to, in my opinion, carry out very extensive raising awareness campaign among citizens to make them understand about all the benefits of EHDS and to teach them about their rights and, as I said, benefits of EHDS. Because if they don't trust the system, this will be a big issue. So first they need to understand what EHDS is, so they can trust it. So I think that first we need to start with educating citizens. Second level, digital health authorities, health data access bodies, and DPOs. So this is like something that's very important. Education is very important.
I think the point about DPOs is really well made, because we know they're coming under so much pressure and resourcing pressure with all of the additional digital regulations, which can distract or detract from the core GDPR role. So I hope one of the outcomes of this isn't that we see DPOs across the entire healthcare system just quitting their jobs in despair. Was there a question in the front here? Yeah.
Can I? No? Okay. So thank you very much. This is very interesting and also very, very complicated, like always for legal aspects and especially with international aspects. And also, like always in those domains, the differences between what is in theory there, legally, and the practical aspects are very, very important, especially for the citizens. So if I understand correctly, in one sentence, you don't have GDPR or EHDS, but and, okay? And in the GDPR, there is one thing that's positive. in my opinion, very caricatural. There is probably only one thing really very useful for the citizens. It is the right to have access to your own data. So I want to know, concerning health data, at the level of the European Union, so Belgium and other countries, is this theoretically the case that a citizen can always ask access and receive the copy of his or her health data, or there are exceptions or not? Because if it is that, I think, if it is really the case, I think it is very positive. But okay, just try, you go to your doctor and you ask, please give me my health data, and you will see how easy it is. I mean, yeah, it is easy, the answer will be no. No, okay, I'm exaggerating a bit. But are there exceptions for these rules or not? Thank you.
Yeah, so I might start on that question, I suppose, with going back to the point that the EHDS makes it clear that it is without prejudice to the GDPR, and their complementary additional rights not competing. And as Anna Maria discussed, when we talked about kind of the parallel systems, there are different things. So your EHDS will be your patient access into the portal, supplied at member state with certain visibility. But the right of access under GDPR, as you say, is to more than that. It is to information and access a copy of all data undergoing processing. And the point of that, the reason that access is actually called out in the Charter of Fundamental Rights is because information and access is the key to exercising all of your other rights under GDPR. You know, you can't understand if your data has been processed unlawfully if you cannot get information and access to it. You cannot rectify your data if you cannot get information and access to it. So I think it's vitally important that these things remain separate and distinct. But I think your point is really well made, that the individual, the citizen, is not confused and understands which mode of access is which. One of the other areas that this will come up is complaint handling. So an individual, there are complaint mechanisms under the EHDS, but there is also a requirement that the Digital Health Authority will be able to transfer a complaint that looks like a GDPR complaint to the Data Protection Supervisory Authority. This is going to be very difficult to work out in practice, to decide at what point is it a complaint about digital health access, and now is it a complaint about a person's data protection rights. In the implementing legislation, we will need to provide those bodies with a sufficient legal basis to transfer personal data between them. Because at the moment, George Esham mentioned HIQA in Ireland, which is our Health Information and Quality Authority. They can't transmit a complaint to us. They have no basis in law to do that. So this is something that's going to have to develop, and it's going to have to be very clear to the citizen which type of complaint they want to make. Presenting the individual citizen with a range of authorities for a range of different rights and actions will only lead to confusion. And I think back to that fundamental idea that transparency is going to have to underpin this.
Can I just briefly jump in to answer the question? I think also under GDPR, there are exceptions to the right to access, and they can also be provided by member state law. But contrary to GDPR, EHDS substantially narrows the possible exceptions to that right of access to your health data. And it's really linked to, I think, medical deontology about, well, you might be diagnosed with something or a result might come back for a particularly harmful disease, which actually your practitioner should actually sit you down and talk you through rather than you just log on, on your MyGov app and have a look and find out you have this illness without being able to have somebody there to help you process that and explore possible treatment options. But even then, it has to be limited in time until there is such a moment to sit you down and talk you through that. So I do think that there's quite a strong right of access here. You asked, are there exceptions? The answer is yes, there is an exception. But again, it's narrowing that exception specifically in the health context. And I think in a way that does strike an interest, also takes into account the interest of the patient. Yeah.
I think we have two down the front here, if we could get the mic down.
Just a very small reminder because we're running out of the time. So we will have one more question for the back area. And And for other questions, you're welcome to talk with the speakers
Yeah,
bilaterally
please do
after
catch
the
us over
session.
coffee. I think we have time for only one more.
So who wants to ask?
Who has the best question?
First of all, thank you for the great discussion. My name is Hale Asgarnia. I'm privacy lawyer at Radboud University Medical Center, and I have a question to Anna Maria. So you mentioned that it's very important, and one of the responsibility of health data access body is to check and assess the legal basis for data. And so I'm talking only about health data, not sensitive health data. So it seems to me that the aim of the EHDS is to change the legal ground from consent or legitimate interest at the data collection to compliance with the legal obligation at the making data available phase. So that's the only legal ground for making data available, if I'm not mistaken. And then I was wondering how health data access body can assess, because there is only one legal ground based on EHDS.
I will ask Brendan to help me with this.
No, so if I understand correctly, the question is where does legal obligation fit into this, and where do the other lawful bases within the meaning of the GDPR fit into this? And I think the EHDS regulation does create a legal obligation within the meaning of 6.1c for data holders to go and make available the data through the process which the HDAP will establish and supervise. And part of that process is an application, which Anna Maria alluded to, and in that application, the requester, the applicant, also has to identify the legal basis from its perspective, because obviously it's not under a legal obligation to go to the HDAP and access the data. No, it has a certain use case or purpose in mind, and for that, it still needs to demonstrate.
I think the 3D for legal basis, I guess, right?
Right.
Consent. Yeah. I mean, then the requester has to, I think there are 3 legal bases that they can demonstrate, if I'm not mistaken, that it's whether they have consent, legitimate interest, and public interest, yeah.
Yeah, but I think these legal grounds are only applicable at the data collection stage. So, and it's the responsibility of health data provider to make sure that, for example, at the data collection, at the data registration, consent and informed consent in a best manner, for example, obtained. But for making data available, once permission is granted by health data access body, data provider are obliged to make their data available. And the legal ground for making data available is compliance with the legal obligation, not consent, not legitimate interest.
I think that's our shared understanding, that the legal obligation you refer to applies to the data holder to provide and to the HDAP, but the party that wants to then use the data through access provided by the HDAP for any one of the permitted purposes must identify a legal ground, because that's not subject to a legal obligation. That's subject to their own underpinning purpose, and whether they come from public sector, private sector, the nature of their own identified purposing process. But you're right that what the regulation does create is a legal obligation to center the data, give it to the HDAP, and the HDAP will then make it available. And this was hugely opposed in Ireland from a lot of the healthcare providers, particularly in the private area, that it's seen as an imposition on the healthcare sector to do something that's very unnatural and very non-native to their way of being, which I think has been a very interesting conversation.
Yeah, just as a very small question. So from the data user perspective, what the legal ground would be? So the legitimate interest is the only legal ground.
So they can indicate one of the 3 from Article 6, which is consent, public interest, and the legitimate interest.
Yes, but the public interest doesn't apply for any other purposes. For example, if data user request for scientific research, for example, or for education, then public interest ground doesn't apply for that. And the legitimate interest is the only legal ground for that. No?
I definitely think this is a conversation worth continuing over coffee, but there is very much an access, there is also provision by public authorities, and they have to actually demonstrate, and it could be scientific research, it could be another secondary purpose that is linked to their mission as a public authority, and there's limits actually as to who can, indeed, you have to be either that entity or another entity acting on their behalf, but then has to be linked to that mandate of that public authority, and then their lawful basis is very much going to be tasked in the public interest.
Yeah, exactly.
Okay,
So,
thanks, folks.
yeah.
I'm going to have to wrap it up there and getting evil looks. But look, thank you so much for listening to our panel. Thanks to my colleagues for participating in this conversation. And we'll let you go and have your coffee.